Ikra, am I audible to you? Hello? They just left.
Hi, good afternoon. Hello.
Afternoon, are we audible to you?
Yes.
Um,
Sorry, there are some technical issues going on, so everybody's trying to join.
got it.
Of course, of course.
Thank you.
Thank you so much for the update.
Hi, please have some patience. They're just trying to get the technical issues, sorted, and we are waiting for the other two judges as well. So that's the reason. Just be patient, please.
Hi. Hello.
Hello.
Hi. This is the round for Maharashtra National Law University. Am I audible?
Yes, you're audible, Marjorie, but your voice is, cutting off in the middle.
All right.
Hello?
Yeah, hi.
All right. So this is the round. Is there still feedback? Can I please ask the participants judges to open their cameras? Sorry?
Please switch on their cameras.
Yes.
Good afternoon. Just to verify, am I visible and audible?
Yes, you are.
Thank you.
Are all the members of Maharashtra University present?
Yes, we're here.
Are all members of the University of Nigeria present?
My co-counsel.
Sorry, are all members of the University of Nigeria present? Hello? Am I audible?
Yes.
Can we just get a response from the University of Nigeria on whether all participants are present? As for the judges, I am able to see that Ikra Islam is present
Yes, I'm present.
and Rishab Jagani is present, correct?
Yeah, ma'am.
Perfect. And we also have Anton Maltsev. Anton, can you please open your camera and mic? All right, if not, I think we can go ahead with Ikra Islam and Rishab Jagani starting the moot. So can the claimant
There's
please
there.
begin?
The university.
Maharashtra University and University of Nigeria.
Is University of Nigeria, yeah?
Yes, So the claimant will be Maharashtra University, and the defendant.
Okay, since we are beginning with University of Maharashtra, can you both the councils please write your names, and if you're senior or junior councils, on the chat, please. Okay, the senior council may begin now.
Hello?
Yeah, hi.
Yeah, am I audible and visible?
Yes, you are.
Right. Greetings, everyone. I'm Varsha Venkat, and along with my co-counsel, Mr. Akshay Jayal, we represent the claimant Artemis Astrophia in the present matter. If it may please the court, the counsel seeks permission to refer to the bench as Your Honor.
Sure.
Yes, you can.
Much obliged. For the convenience of the court, may the counsel present a brief set of facts at hand.
Yes, please do.
Sorry,
You may-
I'm not sure if I can see Miss Venkat.
Am I not
She's
visible, sir?
popped out for a second. Sorry, Miss Venkat.
Am I not visible?
Hello.
Oh, yes, Your Honor.
You should proceed. Uh, Miss Islam, let me know if you have any difficulty.
No, I can hear and see her. So, yeah.
Perfect. Awesome.
Sorry, Varsha, we cannot see you or hear you anymore. I don't know, something is wrong.
If I may just have a minute to check my connection.
Yes, please do.
Yeah, is the respondent on? Because I don't. Respondents team, University of Nigeria, there. They just sort of let us know if they are to your.
The University of Nigeria, but is not here yet.
I'm sorry. I think someone did speak, but then I don't know what they said.
Hello. Am I audible and visible?
Yes, you are.
All right. Are the judges all here?
Rishabh, can you hear us? Yeah, okay.
But I was just hope. Otherwise, we don't know how to proceed, right?
No, I think they are in the room, but it's just they're facing some technical issues. That's what I understand from University of Nigeria. But let's just
Can see
begin.
that.
And
Okay, you want to begin? Okay, cool. Sure.
yeah,
May I start from the beginning or should I just continue?
can you please start from the beginning? It would be better. Thank you, Council.
Yes, Your Honor. Greetings, everyone. I'm Varsha Venkat, and along with my co-counsel, Mr. Akshay Jayal, we represent the claimant Artemis Astrotia in the present matter. If it may please the court, the counsel seeks permission to refer to the bench collectively as Your Honor.
Yes, you may.
For the convenience of the court, the counsel seeks to present a brief set of facts. The claimant is a professional YouTuber and relies on streaming content as her main source of income. She entered into the space flight agreement, hereinafter referred to as the agreement, with the defendant who engages in providing trips to Space Yoga Mat, which is a space yoga retreat, hoping to make profits out of streaming the same. The claimant had also suffered persistent headaches recurring for the past and had continued to be a high functioning individual. Post this, prior to the months leading up to the travel to Space Yoga Mat, a new strain of COVID named Vulcan was discovered, which spread at a far higher rate, and thus the spaceflight participants were given both an lateral flow test along with a PCR test to detect the same. However, the defendant proceeded with the flight only relying on the results for the lateral flow test, which have been provided in the clarifications to not be as accurate. And in the PCR test, the claimant tested positive for COVID. She was isolated mid flight, and the trip had to be cancelled prematurely returning to Earth, causing severe economic loss to the claimant. Given this context, the claimant has two submissions to make. Firstly, that the defendant committed a tortious wrong as well as breached the contract, making them liable to pay 15 million US dollars in damages. And secondly, that the claimant has not committed a contractual breach, and this particular counterclaim would be dealt with by my learned colleague, Mr. Akshay Jayal. Both of us would be taking 15 minutes for our main submissions and reserving 5 minutes each for rebuttals. For our first submission, we submit that the claimant firstly that the defendant committed a tort, and secondly that the defendant breached the spaceflight agreement. Our first submission rests on two grounds. Firstly, that the defendant engaged in gross negligence, and secondly, that the assumption of risk under the spaceflight agreement does not apply. Your Honor, under Article 17 of the Law of Obligations, there are three conditions that must be met to establish negligence. Firstly, a duty of care must be owed by one party to another. Secondly, this duty of care must have been breached. And lastly, this breach must result in economic loss. We firstly contend that the defendant owed the claimant a duty of care, which can be established in line with Article 18, Clause 1 of the Law of Obligations, which provides three conditions. Firstly, the foreseeability of the act causing the harm. Secondly, the proximity between the act and the consequence. And lastly, a fair and reasonable expectation that the defendant owed this duty of care to the claimant. With respect to foreseeability, we rely on the judgment of Aegis Reserves versus Union Bank of India, which is a 2021 case by the DIFC Court of First Instance. Under this, two things were established with respect to foreseeability. Firstly, that the damage and the assumption of risk that any party assumes must be reasonably foreseen. And secondly, in order to establish a proximate cause, the most direct action that caused this damage must be looked at. For our first submission, We state that it was extremely easy for the defendant to foresee the consequences of the action. It was widely known that the Vulcan virus was spreading. Furthermore, it was also widely known that it could spread far more easily as opposed to the easier trap. Given that the space flight is an encapsulated space with a smaller confine, it is a foreseeable consequence that any positive testing would lead to a far more repercussions on the space flight. Hence, the condition of foreseeability stands fulfilled.
Counsel, I have a question. So, could you elaborate more onto this point of foreseeability? How do you think the claimant actually argues the fact that the defender should have foreseen the financial impact on participants like herself? Can you please elaborate that point? Thank you.
Indeed, Your Honor. Pursuant to Article 3 of the spaceflight agreement, if the defendant had simply waited for the
Sorry,
PCR
Varsha, I
test to
cannot hear
return.
you.
Am I audible now?
Yes.
The answer to your Honor's question can be found in Article 3 of the Spaceflight Agreement, which provides for provisions wherein, under circumstances prior to takeoff, the flights can be cancelled and rescheduled as per the participant's convenience. The defendant was aware of the fact that COVID was at spread and hence conducted an LFT and a PCR as well. It was within the defendant's power to go ahead and cancel the test or to go ahead and cancel the flights or reschedule them in order to confirm the diagnosis from a PCR test. But they refused to do so and hence forwent the option. Furthermore, under Article 2, Subclause 2 of the Spaceflight Agreement, if such cancellation does not take place, the participants are not entitled to a refund, and hence, by not cancelling the same, the defendant was aware of the economic repercussions that all participants, including the claimant, would suffer.
Okay, thank you, counsel. Please proceed.
For a second leg, we establish proximity, which is a direct relationship between the act and the consequence thereof. The usually applied test to determine such causation is the but for test, which means that if a certain action of the defendant is directly responsible for the harm that has occurred, a proximate relation can be established. In the present dispute, if the defendant had merely waited for the PCR test to return, the spread of Vulcan could have been entirely avoided, and the claimant would have been entitled to a refund of the amount that was owed to the defendant. Apologies, am I audible and visible now?
Yes, counsel, you are.
Apologies, Your Honor. In
It
the
is okay. It's all right. Yeah, can you please resume?
In the present instance, if the defendant had simply waited for the PCR test to return, the spread of Vulcan could have been simply avoided. This is. Um, could you kindly mute yourself? Okay.
Kindly, can all the other participants who are not speaking mute your mic, please?
To establish a proximate relation, we submit that furthermore the defendant had the option to cancel or even reschedule the flight, but neglected to do so, thereby making them directly responsible for the claimant's condition and the economic loss. Lastly, we submit that it was a fair and reasonable expectation from the claimant to expect such duty of care on two grounds. Firstly, the defendant's sales representative confirmed the claimant's belief that the space flight would have health benefits. And secondly, The space flight agreement specifies that the defendant prioritized the safety and success of the mission in Article 1.1 of the same and had options to ensure the same, such as rescheduling them. However, the defendant neglected to do so and thereby breached the duty of care that the claimant placed reliance on. Secondly, we submit Secondly, we submit that the claimant did not assume any voluntary risk of the Vulcan virus spreading under the agreement. We submit this on two grounds. Firstly, that assumption of risk is only for foreseeable consequences related to an action and not a general condition. We furthermore rely on the judgment of Mohammed Sadia versus Alami Partners, which is a DIFC court judgment of 2020, wherein it was clearly specified that assumption of risk needs to be specific to the activities in question as opposed to a general commercial risk that the participants undertake. In the present circumstances, both the parties in the agreement have adopted the Regulation on Human Spaceflight Activities of the UAE 2022, Article 6.1.I of which states that the spaceflight provider is obligated to relay any risk associated with human spaceflight activities for the This, read alongside Section 55 of the Law of Obligations, clearly mentions that the participant is only entitled to assume that risk which they willingly chose to engage in as part of the activity in question. Nowhere under Article 4 of the agreement that the participants signed does it mention anything regarding COVID, and the only mention of any unforeseen circumstances arises with respect to Article 4.4, the preceding paragraphs of which mention that there can be emergency or unforeseen circumstances and detail three conditions for the same. Firstly, that there may be technical lapses or delays that are unaccounted for, and secondly, that may lead to procedural and itinerary changes. The risk of contracting Vulcan is not related or restricted to participation in the human spaceflight operation, and hence the claimant did not assume the risk to contract the same. Thus, we submit that the defendant was negligent in this action and no voluntary assignment of risk can take place thereof. If the court has no further questions of me.
Yeah, I have one question. So, one second. So sorry. Yeah. So, how does the claimant argue that the omission regarding her medical condition does not constitute misrepresentation under laws of obligations of the DIFC?
Your Honor, for a lo- for any statement to count as misrepresentation, mere silence does not suffice. Pursuant to Article 29, Subclause 5 of the Law of Obligations of DIFC, no representation is not misrepresentation unless it's in breach of a specific duty to disclose. Under Article 5.3 of the Spaceflight Agreement, the claimant was only required to acknowledge that true and complete information must be provided, but was not obligated to provide the same. And further, there was no change in the medical condition of the claimant going forward as well, as the claimant was subjected to these headaches for a recurring period of over 5 years. Hence, the status quo had not been disrupted when she experienced such a headache again during just prior to the takeoff that happened.
Okay, thank you, counsel. Rishabh, do you have any questions? Yeah, okay. Then we shall proceed with the senior defendant, please.
Good afternoon.
Good afternoon.
Do I have the court's
Good
permission to
afternoon.
proceed? Good afternoon.
Yes, you have the
Yes,
permission to
please.
proceed here.
Alright. May it please this honorable court. My name is Uzochukwu Chinedu Chisum, and I am appearing as the senior counsel to the defendant, along with my co-counsel Chikeze Praise Olomachi. And I'm here to offer my client's statement of defense to the claims made by the claimant's counsel. And in
One
the
second.
distribution of
Request you to
our
slow
time,
down.
okay,
I don't
okay.
know if it's the
Should I recap
network.
on all that I've said?
No, no, you don't need to recap, but uh,
Oh,
and
okay.
I'm not sure what the issue is. So if you slow down, it's easier for. There's some technical issue which we
Oh,
will, of course, keep in mind.
okay. So as regards the distribution of time between myself and my co-counsel, I, as the senior defendant or the senior counsel to the defendant, I will be making use of 13 minutes and 10 minutes for my rebuttal, and my junior counsel will be making use of 12 minutes and 10 minutes for a rebuttal, totaling into 45 minutes. I seek the leave of the court with permission to continue with my argument now that that has been stated.
Yes, please proceed.
Okay, Your Lordship, before I delve into our statement of defense, it is pertinent that I draw your lordships to the relevant facts of this case, provided in the uncontestable facts of this substantive suit, with the leave of the court, of course. Now, your lordship, it is
I think
according to the
we are aware of the facts. Do you want to proceed to your arguments? It will be more efficient.
okay, I may proceed I may proceed to my arguments.
Yes, please.
Okay. According to the facts that were stated, the it raises the grounds on it raises the grounds or issues to be addressed in this suit, and now the claimant is bringing an action as regards the liability of our clients in both torts and a breach of contracts. Now, under the first general issue, which is the liability of my clients in torts, it is our submission that our client avers that the claimant is in substantial our client avers that that breach of contract is a failure by a party to perform any one or more of its obligations under the contract. And Ms. Astrotier claims that our client is in breach of safety obligations, which are, of course, covered under Part 7 of the Space Flight Agreement. Now, to further expatiate on that and to argue on that, our clients will be bringing up the defenses of obvious risk and also some of the tenets of equity. Now, it is a widely accepted tenet under equity that he who comes to equity must come with clean hands. And while this defense is not saying that that the suitors have to be blameless, it posits that whoever is coming to seek for for liabilities or to seek for remedies under the law must make sure that they in fact fulfilled every single thing that was required of them. Now, in the light of this statement, I would like to draw the attention of the courts to section 5 sub 5 of the space agreement of the facts in question, where the claimant in flagrant breach of the position of the contract failed to disclose a medical issue, which was an headache. Now, this naturally might be argued by
Sorry,
the claimants as having no.
you're actual breach, which is what is entitled from claiming equitable relief. Is understanding it clearly.
So, Your Honor, please can you recount that? I didn't get what you said.
Okay. I think your argument is that the claimant to comply with the provision of the contract, which does meant that they're not document. I think
I don't know if you can hear me currently, but I'm experiencing some form of technical issues. I can't hear what the honorable judge is saying. Well, sorry, I really can't hear what the judge is saying. So, with the leave of the court, I would like to continue my argument.
Yeah, please proceed.
Oh, okay, okay. So, standing on all that has previously been said, uh, I would like to rely on the undisputed facts of the case that it is impossible for the claimant to aver that my client was in breach of any safety protocol as at any given point during the duration of the contract. Our client's safety protocols were in full compliance with all applicable laws as indicated under paragraph 7.1 and paragraph 7.2 of the agreement. And my client also provided the claimant with a comprehensive safety briefing days in compliance with paragraph 7.4. Um, it's equally important for the court to note that my client's cancellation of the retreat, though which may constitute a non-performance, arose as a result of it arose as a result of circumstances which were beyond my client's control. And it is also our argument that such non-performance as is being raised as a case on the part of the non of the on the part of the claimant should be struck out because the relevant facts show that the claimant is totally not in the free of every single form of damages that occurred. Now, why would we say this? From the relevant facts, we can see that the claimant indeed read the agreement on the day of purchasing the ticket. Now, by reading the agreement, it is obvious that she was conversant with the facts of the agreement, and she accepted to all those terms in the contract. And then reading further into the facts, we can see that the claimant did in fact know that the headache or the chronic headaches that she was experiencing would have served as a form of hindrance on a general eligibility to participate in my client's space retreat, and she willfully failed to disclose that. And the relevant facts show that she had a cause to do so, and that cause was because of her fear that my clients may, on the basis of her disclosure of such headaches, may determine that she would not be fit and proper to participate in the space retreat, which was organized by my client. So it is our submission
Yeah,
that
sorry,
on the
counsel. I have a question.
yes,
So, how does
yeah.
the defendant justify the fact that they proceeded with the space flight before receiving the results of the COVID-19?
Well, my on that, I would like to say that the actions of my clients at that time would have been um same as any reasonable person in that position. And why would I say this? According to the relevant facts of the case, uh the window for lunch, or should I say the time frame which they ought to have moved, and not just because of their wanting to move, but because of meteorological conditions require that they move at that specific time. And also as at that time, as evidenced in the clarification document sent, as at that time, lateral test and the PCR test, there was no way to infer that being negative in the lateral test could purportedly get evidence of some Vulcan virus. And so that was enough justification that in a reasonable medical practitioner to give the green light for that lunch, and to allow our clients to go on with the space retreat.
Yes, I understand that, but still, by proceeding, did they put everybody's health on risk? So that's what I want to clarify. How is that justifiable
Well,
and not a duty?
well, Ma, as regards that, while we want to, you know, hammer on the issue that the particular person and not just the general house that we're on risk is basically astroturf, we would like to say that following the the agreement or the space agreement, uh, our client had no cause to believe that that there was going to be any damages or any subsequent outbreak, because they had in fact fulfilled every single duty of care that was owed to every single participant. And how did they do that? They did the initial medical test and medical evaluations, and also did a medical evaluation before the launch. And there are facts to show that all of these tests actually did not prove evidence of any hazard or any dangers. And so my clients had reasonable had enough reasons to believe that going on with the space retreat as at that time was in fact not going to posit or show any further signs of damages or dangers.
Okay, thank you, counsel. Please proceed.
Okay, more. And now on the second issue of my client's breach of contract, I'd like to say that I'd like to rely on two basic doctrines of or two um acceptable principles of law, which are under the contract. The particular ingredients of a contract are an offer, an acceptance, consideration, and intention to create legal relations. Now, while all of these were available, some defenses to a contract agreement involve frustration of purpose and force majeure. Now, the argument on the side of the claimant is that our clients, by canceling the space retreat, was in fact in a flagrant breach of one of the fundamental terms of the contract. But Your Honor, it is our humble submission that, in fact, the cancellation was reasonable as at that period. Our clients its staffs and crew were faced with an outbreak of a COVID-19 virus, and it was something that was really affecting every single participant. And as at that, and because of that, we had to cancel the retreat. Now, why claim that we canceled the retreat? We would also like to draw the attention of the courts to the fact that in the clarification document sent, that we had in fact sent out a memo to every single participant telling them that we would reach out to them with further terms. And also in one
Apologies,
of the
apologies, counsel. You just have a minute, so
yes.
would you like to just conclude your submissions? Thank you.
Okay, okay. To conclude my submissions, it is a submission that our client is in fact not not liable in torts, because the claimant is not totally in the right, because she willfully and she misrepresented facts by willfully obstructing the knowledge of her headaches to my clients. And if she had done so, then it may have raised some additional duty of care on the part of my client. But my client did all that was reasonable to every single participant that was involved in that space retreat. And on the issue of breach of contract, we would like to plead force majeure. The circumstances were beyond our control, and any reasonable person would have wanted to cancel that retreat. And in doing that, we did not just cancel it and then go mum. We actually reached out to them and told them that we were going to reach out to them further on further signs. So it is our humble submission that the claims of the claimant cannot be allowed to stand. Thank you very much.
Okay, thank you, counsel. We will proceed with rebuttals now. So, senior claimant, please, you have the floor.
Just confirming I'm perfectly audible and visible before I begin.
Yes, you are. Thank you.
Thank you so much, Your Honor. In response to the defendant's submission, I have three rebuttals to make. Firstly, regarding the standard of care being insufficient. Secondly, regarding there being no duty to disclose on our part, and even if there were, we weren't in breach of it. And lastly, that this was not in fact a cancelled trip, but in fact a clear breach of agreement thereof. To address the standard of care, we placed reliance again on the case of Aegis Resources versus Union Bank of India, wherein a bank was being sued for negligence. A standard of care was thereby derived by the DIFC Court of First Instance, wherein specialized professions were to be adjudicated not on the basis of what any reasonable average individual would do, but what their professional obligations dictate. In the present circumstances, it is a space flight operator with knowledge of the fact that a new strain of COVID, Vulcan, is rampantly being spread. This is the exact reason why they conducted both an LFT as well as a PCR test. However, instead of going ahead and waiting for the PCR test to be returned, they relied only on the LFT results, which were clarified in clarification number 4 to be not as accurate for testing Vulcan in the first place. They relied on the advice of a mere nurse regard, and did not even bother to take a second opinion while going ahead and engaging in a multi-million-dollar operation of sending a human spaceflight expedition. Furthermore, despite knowing that Vulcan spreads at a faster rate than normal COVID, they put over 20 participants together in an enclosed space, proving a clear disregard for the safety of the passengers involved. Hence, the standard of care that the defendant exhibited is by no measure reasonable given the professional expertise that is expected of them. Secondly, regarding the duty to disclose. Pursuant to Article 4.4 of the agreement, the claimant was only required to acknowledge that they needed to provide complete information, but there was no obligation placed on them to do so. If the contractual drafters wanted there to be such an obligation, all they had to do was remove the word acknowledgement and just state clearly that the claimant is obligated to disclose all of them. The clear use of the word acknowledge specifies the intent of the drafters that it was an informatory and not a mandatory provision of the contract.
Sorry,
And
sorry, sorry. Can you your
uh,
argument that you had a duty that they close because it was, I mean, I think I follow your argument. Could you just elaborate your argument a little better?
indeed, Your Honor, our argument is firstly that the individual who entered into the contract used a very specific term, which is acknowledgement of the importance of providing complete information. This was not an obligation placed on the claimant to do so, which means all they
Take
had
your
to do to
position that parties under contractual law are not information to the fullest as a matter of law.
apologies, Your Honor, you disconnected in between.
Oh, brilliant. I'm saying, is it your
Risha,
to
would you find it
disclose?
easier to just type down the question so that she can answer?
Just turn off
Because,
the video.
yeah,
If I, if I turn off video, is it better?
yeah, it is
Yes,
better.
Your Honor.
That there is no legal obligation to disclose interplay of words used in the contract. Is that your contention?
Your Honor, that is the first part of it, which means to give effect to every term in contract. And the correct term being used in this agreement is an acknowledgement as opposed to an obligation or even removal of the word acknowledgement, which will clearly resulted in an obligation. However, if that does not satisfy Your Honor, we further submit that we did not breach this agreement at all, which means even if we were to disclose any changes in circumstances, the headaches were a recurring nature for the claimant in and of themselves. Which means if you've been subjected to a condition for over 5 years and all of a sudden you have another headache, it is extremely unreasonable for any party to expect the claimant to go ahead and categorically connect it with COVID, especially when she was not symptomatic of any other symptom showing up at the same time. Lastly, we submit that
Was there a requirement? I mean, a is your contention, which is fine. Sorry, I think I have to keep ever is your contention, correct? You suddenly had one symptom of the many, and
yes, Your Honor.
in your interest, not a public safety concern, that uh, for your personal reasons. Is that reckless caution?
Your Honor, I believe it would be pertinent to mention the fact that the claimant was not symptomatic of any other concerns coming thereof. If it's a recurring condition and the claimant simply thought of it as another headache in a long line of undiagnosed headaches for over 5 years and was not showing any other symptoms, it is fair to assume that the first thought the claimant had was that it is just a normal headache as opposed to connecting it to COVID. It was only after takeoff that the PCR test confirmed the same, post which her condition debilitated.
So,
Um,
what about the risk that you put others under? I mean,
Your Honor, regarding the assumption of risk, the claimant at no point in time went ahead and assumed the risk that they'll be contracting COVID. Furthermore, it is the defendant's obligation as they entered into the contract with every participant, including the claimant, to provide a safe and successful flight, as opposed to going ahead and placing this burden on the claimant in and
the
of themselves.
respondent is obligated to provide a safe and successful flight, entitled to information which is critical in this sense of how you would treat the contract. Am I correct? So
Uh,
the respondent's information which you believe it may or may not be entitled to is,
your
I don't think I can hear you.
Okay. Your Honor, with respect to this, the parties also adopted the Space Industry Regulations of 2021, wherein and under the agreement, the claimant was required to disclose conditions that may affect her fitness to fly. Under Article 72, Clause 2 of the Space Industry Regulation, fitness is defined only by three criteria. Number
Mhm.
one, the ability to withstand the physical and mental rigors of a space flight. Secondly, ability to perform any critical functions. And lastly, ability to carry on emergency procedures. Only post which such medical clearance is given. The defendant conducted a thorough medical checkup of the claimant and cleared the claimant to be fit to fly. The headaches and the non disclosure of it thereof did not affect the claimant's fitness to fly in any way, and
No, no,
hence
but
we also.
do and am I
Yes,
correct? It was your voluntary be aware of. It is physically not possible for a person to, other than with say that you have a headache. Am I correct?
indeed, Your Honor. If I may present an alternate argument on this.
Yes, of course. Let's hear you out.
Thank you so much, Your Honor. Your Honor, in this situation, let us calculate the chain of events that took place. The claimant's fault rests in the fact that perhaps they were in breach of an obligation to disclose, which we contend did not exist in the first place. But assuming this to be true, the claimant did not disclose a headache that occurred. However, the respondent went ahead and breached the standard of care, did not wait for results, did not get a second opinion at play. At no point in time were the claimant's disclosure of headaches or none thereof should have been responsible for the defendant assuming a certain standard of care that was expected of them in the very first place. At such a yes, Your Honor.
It's done, right? There was another sort of LFT done.
Yes, Your Honor.
The respondent did carry out an LFT. Am I correct, or am I wrong on that?
Your Honor, the respondent carried out both an LFT and a PCR test. The LFT has been clarified to not be a reliable source. However, even assuming that the defendant relied on the LFT and took the advice, it is a multi-million dollar commercial operation that the respondent is carrying out. They did not go ahead and consult another doctor. They did not wait 1 hour more for a PCR test to return, and they went ahead and threatened the lives of so many individuals by not waiting for a more accurate test.
So
Hence,
your argument is you don't think that the
um, apologies.
is symptomatic, but because the contract is what you say puts everyone's lives in danger because it am I
Your Honor,
correct?
Your Honor, you cut off in between. I couldn't make out what your question was. Apologies.
Go ahead.
May I continue?
Yes, please
You
do.
may.
Okay, I think they asked us to wait.
He did? I can't hear him. Sorry.
Even I can barely make out what they're saying.
Yeah, just proceed, please.
With respect to this submission, we have three layered arguments. Firstly, that the wording of the contract does not necessitate that there is an obligation to disclose. Secondly, we did comply in case there was an obligation, given that there was no change in circumstances given the recurring nature of these headaches, and that the claimant had no reason to think otherwise. And lastly, even if this did occur, proportionate allocation of liability must be assigned, which means the claimant's breach, which was a non disclosure of a headache, which in the long term should not have affected the reasonable standard of care that the defendant should have taken anyway, versus the defendant flouting every standard of care that they should have taken for a multi-million-dollar commercial operation, which resulted in the compromised safety of multiple participants and direct economic losses to the claimant. With that, if I can be of no further assistance to the court, I would like to conclude my rebuttals.
Thank you. I would like to hear from the senior defendant, please. The Sarabado. Senior defendant.
Hello, can you hear me? I'm trying to like turn it on. Can I get a minute?
Yes, yeah, sure.
Uh, okay. Uh-huh. Hey, please, the honorable court. I'd like to go ahead with my story button now.
Yes, please proceed.
Okay. Thank you very much, Your Honor. On the first issue of the rebuttal that was raised by the claimant about the standard of care, uh, I would like to draw the attention of the court that the standard of care, which is which should be tenable in this kind of circumstances, that of a reasonable man. And it is also a submission that by doing all the necessary tests and all the prerequisite tests, by organizing the pre-medical evaluation and the evaluation before the space travel and all that, that we in fact did effect every single duty of care that we owe to the claimant, and the claimant cannot in actual fact claim to the negative. And I would also like to point out on something that my learned colleague, the senior claimant, said something about the duty to disclose a change in medical condition, not a fundamental term of the contract. Section, I'd like to state for the record that in the facts of the case, the sole intention or the sole reason why the claimant failed to disclose the medical agreement, the medical issue, which was the headache, was because of her knowledge that should such information be provided to my client, that she may not partake in the space retreat. And also the relevant facts show that she indeed read the agreements on the point before payments and a reception of the receipt. Now this means that she in fact had already seen those clauses and she understood those clauses, and they in turn informed the decision to not inform my clients about that medical condition, which was the chronic headache. And on this, I would like to stand on section on Article 5.5 of the space flight agreement that says that the passenger further acknowledges the importance of providing accurate and complete information, and also knows that failure to do so may impact their eligibility to participate in the space flight. It was obvious that the claimant already read this, and it was obvious that this was in fact the main reason why she failed to disclose the chronic headaches. And now moving on, it's also said in the relevant facts that 2 weeks before, on the second week of the waiting period before the launch, that she in fact had the symptoms of headache and fatigue and tiredness. And from the clarifications that were sent to us, tiredness and fatigue were, valid symptoms of the Vulcan virus. And now the claim on the part of the claimant is that she was already, she knew about the headaches. She was having these headaches for 5 years, so the headaches were nothing new to her, and it did not in any way impact her ability to effect her duties and effect her responsibilities. But according to the terms of that agreement, it was said any change, the headaches that she had were complemented by tiredness. Is the position of any reasonable man there? If let's say we had a headache, and that headache was accompanied by tiredness, it is in fact a duty for the claimant to have informed our clients so that further medical evaluations or specific medical evaluations would have been effected on the part of the claimant. And on the issue of cancellation, which was raised by the senior claimant, according to the provisions of the space flight agreement, specifically Article 3.3, it was clearly stated that in the event of a cancellation by any party, that the parties will undertake reasonable efforts to reschedule the space flight to a mutually agreeable date. Now, reading the fact, the facts which were provided, we would also find that my client did, in fact, after the cancellation, reach out to every single participant that was involved, and we furnished reasons to the cancellation of this said space retreats, and we also told them that we were going to be in contact with them over a possible rescheduling. So saying that the cancellation did in fact amount to a breach, when the possibility or eventuality of such cancellation were in fact included in the contract, and my clients effected one of the conditions of an eventuality. I mean, this was obviously both parties having in their memory that there could be some forces. I mean, this is spaceflight. This is not just boarding an airplane or boarding a train or boarding a bus. This is a space flight. This requires going to space. You understand? And our clients are in the agreement. It is obvious that both parties reasonably foresaw that there could be instances which could be beyond the control of both my clients and which could be in control of my clients. And this led to the inclusion of that clause. And true to the effect of fulfilling that clause, our client did in fact do everything that was required of them to do. And the claimants cannot rely on this as a valid point to the liability of my client in a breach of contract. Now, to end my argument, I would like to draw the attention of the honorable court to the willful non-disclosure by the claimant. Now, from the facts of the argument, we see that this agreement was in fact read and signed by her before she paid the money, meaning she was conversant with these facts, and she had. It's our submission that she already knew what Article 5.5 of the agreement said, that in the case of any change in medical conditions, or telling my clients about her headaches might in fact impact on her ability to go on this space retreat. And it is our humble submission that this non-disclosure was only but a willful, selfish uh, act on the part of the claimant. The claimant did this also. It is also our submission that the claimant did this because she viewed that going out to space, as was represented by our agent, was going to help, draw from the energies of the moons and the stars. And it is our humble submission that the picture of what could be, in fact, did cloud her mind and made her to engage on this non-disclosure. And on this basis, it is our humble submission that no claim in tort and breach of contract can fly, because whilst we actually did fulfill every single duty of care that was required of a reasonable man in our position, the client, was in flagrant breach of one of the fundamental terms of the contract. And on this, I rest my case and make my last submission. Thank you very much to this honorable court.
Yeah, thank you, counsel. Can we please proceed to the junior defendant submissions, please? Junior defendant from the University of Nigeria.
Sorry, honorable court. I think my co-counsel is experiencing some technical difficulties. We pray the leave of the court for the granting of some minutes so that she can be on this call. With, of course, the leave of the court.
Yes, okay, sure. We'll wait. Sorry, we cannot hear you, junior defendant. Can you just try muting and unmuting and then just try to get back into the meeting? Like leave the meeting and get back. No, I cannot hear you. Is there some issue with your microphone? Maybe try headphones.
May I please the Honorable Court? My junior counsel to the defendant is here, and she will be speaking now.
Yes, but we cannot hear her. Yes, you're not audible. I'm so sorry. Sorry, you're not audible. Can you please try headphones? Do you have headphones? Maybe that is the issue. Microphone is the issue. Can you try leaving the meeting and coming back in? I understand the technical difficulties. That's the reason why we are trying to be as accommodating as possible. Yeah. Hi, you're still not audible. Is it just me or can anybody else hear?
I can hear you, Ikra.
Yeah, but can you hear the junior defendant?
Yep, I could hear her.
You can, okay. Okay, then it's just me. Please proceed then, please.
My apologies, but the junior defendant is not audible to me.
Okay, now not to me either. Brilliant. Do you want to turn off your video?
Maybe, yeah, and then try.
Is someone from the DIFC on this?
Not currently.
This platform is pathetic. Nothing is working. Can you turn off your video?
Yeah,
June?
just turn off your camera and let's just try if we can hear you.
Nope.
No, I cannot either. Okay, just give me a minute. Let me just. Just give me a minute. I'm just contacting the people, the DFC organizing committee, so I'll get back. Yes, hi. Hello, Vansh.
Hello.
Yeah, hi. So we're unable to hear the junior defendant.
Okay. What are the issues? What she
Yeah,
is
she's not audible. Can you just switch on your camera, junior defendant, please?
so
Yeah, that is the person. We can't hear her.
so
Hi,
can you see in your settings like
uh, hi, Chikizi. Can you see your settings? Is your microphone working? Can you hear us? Firstly, can you unmute yourself? Can you hear us? Can you check your settings? What microphone is it connected to? Are you able to share screen, Chikizi? Can you share screen and just show us your settings once quickly? Chikizi, can you hear? Can you type in chat if you can hear me?
Hi, Chikezi. On the bottom of the screen, the third button from the left, which says share screen. Can you click on that? Hi, Chikizi. I can also see that you are logged into the Teams main hall. May I request you to log out of there and then unmute yourself and speak? Could you unmute yourself now?
Am I audible now?
Yes, you are.
I'm visible.
Yes. Can the junior claimant also hear her and see her?
Yeah, she's audible to me as well.
Yeah. Okay. Perfect.
Thank you so much. Thank you
Thank
for your
you.
patience on the report.
It's
Okay,
fine.
so good afternoon, Honorable Court. I am Chikeja Praise, the junior defendant in this matter, and I'll be handling the second issue, which is the defendant's counterclaim in this suit. Before I delve into my counterclaim, I would like to, which is the liability of the claimant to my client, the defendant, in breach of contract. Before I delve into the counterclaim proper, I would like to briefly make a statement of the facts, briefly. So the claimant, a renowned YouTuber, got into a contract with my client, the defendant, in order to join or be a participant of a yoga retreat in outer space. However, before she got into this contract, or pursuant to this contract, she signed a space flight agreement with my client, which she had carefully read and perused through. One of the terms of this space flight agreement was that the claimant was to, at all times, report any change in her health conditions to the spaceflight operator and to duly and accurately disclose any health condition that she may have. However, the claimant, who was very sick of a contagious variant of the COVID-19, failed to do this and grievously breached this fundamental and vital term of the contract she had with my client. And as consequence of this, she spread this very dangerous and contagious variant of the COVID-19 to all other participants of the space retreats, and thereby caused a great loss to my clients, including reputational damage, economic loss, and loss of patronage. It is based on these facts that we, my clients, the defendant, is bringing this counterclaim before the honorable court. It is the defendant's stance that the claimant is in flagrant audacious breach of contracts, specifically terms of the space flight agreement and other implied obligations. It would be pertinent to elaborate on what breach of contract is under the law. Pursuant to Article 77 of the Contract Law DFIC, a breach of contract is not just a situation where one party defaults in performing their duties under a contract, but can also include circumstances where one party performs his obligations but performs it defectively or performs its obligations on a later date than agreed. Pursuant to Article 58 of the same contract law DFIC, a breach of contract can also arise in situations where a party fails to cooperate with the other party in situations where that cooperation is vital and elemental to aid in the other party executing their own side of the bargain. It is therefore our stance that the claimant in this matter is flagrantly in breach of the contract, specifically Part 5 of the Spaceflight Agreement, which expressly mandated the claimant to 1. Duly disclose every symptom or duly disclose her medical history. That is, all ailments which she has suffered previously or currently. And 2, to duly, at all times, promptly report any change whatsoever in her health conditions to the spaceflight operator. However, if we pay close attention to the uncontested facts, the claimant on the 12th day of December 2023 was given a medical history log to fill. The claimant was mandated to fill in all, emphasis on all ailments which she has suffered in the past or was currently suffering. However, the claimant flagrantly failed, willfully failed to mention her recurring and chronic headaches. This was a flagrant breach of paragraph 5.2 of the spaceflight agreement. The claimant also went ahead to sign a declaration form that she was not aware of any disease or any sickness which could impede her fitness for the flight. This was also in flagrant breach of paragraph 5.2 of the spaceflight agreement. Additionally, paying close attention to the uncontested facts, from the second week of February to the 15th day of February 2024, the claimant also developed another recurring bout of chronic headaches. The claimant was supposed to report this particular episode to the spaceflight operator. From the facts, we would see that the headaches this time around were accompanied with exhaustion and tiredness. While the claimant can insist that headaches are common to her, chronic headaches lasting almost up to a week and accompanied by headaches I'm so sorry about that. Am I visible and audible now?
Yes, you are. Please proceed.
Okay, thank you very much. Thank you so much, Honorable Court. I was stating the some details of the uncontested facts, which show that um, the claimant suffered from headaches, which were accompanied by exhaustion and tiredness. Now, while the claimant can insist that headaches were common to her, such aggravated headaches lasting almost up to a week and accompanied with exhaustion and tiredness were alien to her usual health complaints. She had never experienced such a thing before. And yet, willfully, the claimant still did not report this significant change in her health condition to the spaceflight operator. This was also in flagrant breach of paragraph 5.3, 5.4, and 5.5 of the spaceflight agreement. I would like to bring to the court's attention the case of Hator and Hela, a DCIF case of 2017. In this case, the defendants were sued for a breach of contract, specifically a duty to disclose. In this case, the claimants held that they did not have a duty to disclose their own wrongdoing to the defendants. However, the court held that the term of the contract, which was specifically a duty to disclose their own wrongdoing, was a valid term of the contract. And therefore, as my submission, I just call this a means this matter in our favor. And grants us our relief sought in paragraph 6.0 of the claimant's signature agreement. I'm so sorry about that. I keep getting logged out arbitrarily.
It's fine. Just proceed. And I would like you to just conclude your submissions after this in within
All
2
right,
minutes.
all
Okay.
right, Honor.
Thank you.
All right, Your Honor. Um, Honorable courts, it's a basic and well-known principle of law that in cases of breach of contract, where the liability for breach of contract usually lies or covers all harms that are reasonably foreseeable by a reasonable person who is in the position of the defaulting party. In this instant case, it's our stance that the claimant reasonably foresaw that her breach of the duty to disclose would have caused such detrimental effects on the space retreat. And it's our stance that a singular act of the claimant failing to disclose her medical condition was a singular act that led to a linked chain of events, a linked chain of reactions, namely one, the failed space retreat, two, the reputational damage to my clients, three, economic loss, and loss of business patronage. All these were harms that came to my clients by virtue of the claimant's singular act of breach of contract. It is therefore my submission. I just call this amends this matter in our favor and grants us our relief sought in paragraph 6.0 of the claimant's signature agreement.
Yeah, can you hear us, junior defendant?
Yes, I can hear you. I hope I'm visible and audible.
Yes, can you just conclude and we will move to senior claimant then for the
All
junior?
right, that was my yes. Um, we are praying this honorable call to grant us our relief sought in paragraph 6.0 of our legal memorial, which includes one, a declaration that the claimant is liable to my client for breach of contract, and two, an award of 5 million US dollars to my client for reputational damage, and any other declarations that this court would deem fit and proper in the circumstances of this case. I rest my case.
Okay, thank you, counsel. Can we please proceed to junior claimant?
Good afternoon. I hope I'm audible and visible.
Yes, you are.
Counsel requests to address the benches, Your Honor.
You can. Please proceed.
Much obliged. My warm greetings to Your Honor. May it please the court that I am the junior claimant in this case, and I shall be presenting the second issue, that is the defendant's counterclaim. As my learned friend, Ms. Varsha Venkat, has already expertly laid down the facts of the case, I request to proceed with my submissions.
Yes, please do.
Much obliged. So, for my submissions, I shall be presenting a three-pronged argument. Firstly, that the claimant did not have an express obligation to disclose the chronic headaches arising out of the contract. Secondly, that there were no implied obligations creating out of the contract. And lastly, that arguendo, any obligations were created, they are defeated on two grounds. Firstly, the degree of fault and the but-for test. And secondly, the subsequent negligence of the defendant. If it may please the court, the counsel would like to proceed with the first submission.
Yes, please.
Much obliged. So, proceeding with my first submission, it is humbly submitted that there has been no breach of obligations with regards to Article 5.2. Turning to page 14 of the problem, Article Para 5.2 reads, the passenger declares and represents that, to the best of their knowledge and belief, they are not aware of any medical condition or symptoms of a potential medical condition that may affect their fitness to participate in a spaceflight. In the instant case, the claimant was admittedly suffering from undiagnosable headache problems for the last 5 years. However, the same have not impeded her ability to withstand physical pressure or to be able to travel recurrently on air flights as she is habitual to doing, as can be found from the para 5 of the Moot problem. Furthermore, in conjunction to the submission, the Council would like to draw attention to the Space Industry Regulations, Regulation number 72, Clause 2. The regulation defines fitness, and I quote, the ability to withstand physical and mental rigors, perform safety critical functions, and execute emergency procedures. Only upon meeting these criteria is medical clearance granted. Crucially, Clause 5.2 of the agreement explicitly mirrors this definition. It obligates the claimant to disclose only those factors that could affect these potential components of a fitness. The uncontested evidence from the record itself demonstrates that the claimant's headaches have not impeded her ability to travel extensively by air or have resulted in any post-travel health concerns. Therefore, the claimant acted reasonably in not disclosing the headaches during the pre-travel examination. The headaches, by their very nature, did not fall under Clause 5.2. Transitioning to my second submission, that is that there has been no breach of obligations arising out of Articles 5.3 through to 5.5. Your Honor, it is humbly submitted that a bare reading of Article 5.3 creates two conditions. One, in case there is any change in the medical condition, or two, if they became aware of such symptoms, including any changes that occur between the initial medical evaluation and the scheduled time of launch. Coming to my first submission, the academic literature on what constitutes chronic diseases is admittedly endemic to variation. Differences in how chronic disease is defined is largely dependent on the data used for the research, the discipline, as well as where the study is being conducted. As per the Center for Diseases of the United States, chronic diseases occur in complex interdependencies and continue across lifespan. The National Center for Health categorizes them as diseases that last over 3 months or more. In the instant case, there was no change in the medical condition of the claimant as a chronic disease is endemic to the entire life of the claimant. In the alternative, if there is no agreement as to what constitutes chronic diseases, the claimant would like to take the defense of a lack of consensus ad item, in which case the doctrine of severability present in Article 10 of the problem activates, and this particular clause of change in medical condition is nullified, while the rest of the contract proceeds as normal. Secondly, if they became aware of any such condition. Now, as is evident from the record, the Claimant had no reason to think, as was addressed by my senior counsel, that the claimant had been infected with COVID. They had been suffering from severe headaches for the past 5 years and assumed that the same was continuing. Moreover, if we read clarification 2 to the Moot problem, it states the various symptoms of the Vulcan variant, and reading this in conjunction with paragraph 12 of the Moot problem, we see that there must be severe and, to quote, debilitating conditions as well as a variety of strains. Now, admittedly, COVID 19 varies from body to body. However, given the circumstances, the special medical history of the claimant, she could not have reasonably guessed that she had been infected with COVID. Furthermore, coming back to the disclosure of the headaches, as the senior counsel for the defendants themselves conceded, it was the sales representative whose long conversation, as is given in clarification 1 to the agreement, which encouraged the claimant to go forth for the trip. Furthermore, transitioning this into my next submission, if there are no questions from the bench,
There are none. Please proceed.
Article 29 of the DIFC Law of Obligations lays down misrepresentation. So, the law of misrepresentation states that a statement of opinion can only be a misrepresentation if it is accompanied by a further incorrect representation, whether express or implied, such that the representee or his agent, acting in capacity as such, has reasonable ground for believing that the opinion is true. In the instant case, the agent of the defendant, the sales representative, encouraged, whether impliedly or directly, the claimant into believing that the cure that she was seeking of her chronic headaches that could be found in the space travel, as can be found in clarification 1 to the agreement. Ms. Astoria explained what she wished to achieve from the trip. The sales representative focused on the modality of travel, but carefully listened to Ms. Astoria and did not suggest that she would be unable to make her objective. The defendant at this point in time had no objection whatsoever to the headaches of the claimant, as they clearly had noticed to their agent. However, they have suddenly brought up this objection at the 11th hour. Furthermore, coming to my next submission, arguendo, even if there is a breach of obligations with regards to COVID 19, it is defeated on two grounds. Firstly, the degree of fault. For this, I would like to cite the case of Glass Private Limited versus River Locking Systems from, apologies. So this system states the but for test. In the instant case, would these damages have occurred but for the conduct of the claimant? The same is not true in the instant case. Even if the breach of the fault is established, more direct harm gets attributed to the biggest claim. Even if the claimant had disclosed the headache, what must be ascertained is whether this disclosure was absolutely critical to the defendant to take the standard of care which they were already obligated to take and which they continue to fail on doing regardless of what happened. They did not, as the clarifications make out, they did not wait for the PCR test to come, even though it was clear at that point in time that lateral tests may not completely be accurate. And at the same time, they were made aware of the COVID 19 diagnosis on board. They were made aware of the COVID 19 diagnosis on board, yet they still chose to dock onto the space yoga mat. The reasoning given for the same by the senior defendant is vehemently denied that they were only taking care of the standard of care, as they were clearly negligent in the current place and they had not docked onto the yoga mat yet. Furthermore, the council would also like to highlight the case stated by the junior defendant, that was Heater versus Hela. So the DIFC law of obligations does obligate a fiduciary duty to disclose their wrongdoing. However, those are only those that case only finds ruling when there is a contract of employment and a fiduciary relationship. In the absence of the same in this case, relevant to the case is not relevant to the argument or the issue at hand. Furthermore, the claimant would now like to bring to the fact the subsequent negligent conduct of the defendant. So there is a doctrine in common law which is enforceable under which has great persuasive value in the DIFC law of subsequent wrong, which has been developed in the United States. So this subsequent negligence, to quote, sees whether the the claimant, which in this case would be the defendant filing the counterclaim, knows or ought to know by exercise of ordinary care of the precedent negligence of plaintiff by his subsequent negligence does the plaintiff an injury, this amounts to a gross negligence of the defendant, which will excuse the contributory negligence of the plaintiff. So even if in the argumento that there was a breach by the claimant knowingly or unknowingly in not disclosing their COVID-19 diagnosis, the latter gross negligence of the defendant, as has been laid down in Gibbard versus Gerson and Strogi versus New York Central Railway Corporation, in common law, the defendant will not be able to put forward their remedies as they have been even more negligent. Lastly, even if the defendant's counterclaim is accepted, that can be set off against each other as they arise from the same cause of action, that is the premature return of the space right. Even in the worst case, the claimant remains entitled to the $10 million in damages which arose from the gross negligence. That is cut down from the 15 million that had originally been claimed, set off against the 5 million that has been claimed in return. The council would
Can you
like
please
to.
conclude your submission?
Right. Of course, Your Honor, the counsel was finished. That's what he was alluding to. The counsel now would like to rest his case.
Okay, thank you. We will just move to junior defendant to the rebuttal. Is junior defendant in the room?
Yes, Your Honor.
Yes.
Thank you for the opportunity, Honorable Court. So I'll proceed with my rebuttal on the defense of the junior claimant. Am I visible and audible?
Yes, please proceed.
All right. So I will be rebutting the junior claimant's defense on 5 points. First, the junior claimant mentioned that the headache which the claimant, Ms. Artemis, had suffered was not chronic. And he also mentioned that a definition of a chronic sickness or chronic illness or chronic ailment was one that has lasted over 3 months. Well, a perusal of the uncontested facts in this case shows that Ms. Artemis has suffered this chronic headache for 5 years and counting. If this cannot be defined as chronic, I don't know what would be. On the second point, the junior claimants had mentioned that there had been no change in the ailment suffered by the claimant, Ms. Artemis, and therefore she was not obliged to report this particular headache to the spaceflight operator. However, I would like to bring to the notice of the court paragraph 10 of the uncontested fact in this case, which specifically and expressly stated that Ms. Artemis had suffered headaches, chronic headaches accompanied by exhaustion and tiredness. While the claimant can insist that headaches were common to her, headaches accompanied by exhaustion and tiredness were alien to her usual health complaints, and therefore was a significant change in her health condition, and she was stipulatedly and mandatorily expected contractually to report this significant change to the spaceflight operator. This she failed to do, and therefore was in breach of the clauses in the contract. Also, the junior claimant mentioned that the contracts, especially clause 5.2, had not expressly provided that the claimant should provide details of her health conditions. I would like to take this court's notice to paragraph 8 of the uncontested facts in this case, which provides that the claimant was asked to list all ailments that she had suffered in the past or was currently suffering. The emphasis, Your Honor, is on the word all. There was no qualification as to the type and the nature of the illness that she was not to disclose. She was to disclose all ailments and sicknesses which she had suffered currently or had suffered previously. Going on to the fourth point, the junior claimant had mentioned misrepresentation. I would like to bring to notice of this court that we had in no time mentioned any claim of misrepresentation on the part of the claimants. Our counterclaim is solely on breach of contract. I would like to take this court notice to the case of the Court of Appeal case of Salem Dweller and Damak Park Towers Company Limited. In this case, the court held, and I will quote by the leave of the court, of course.
You don't need to quote.
I would quote by leave of court. No claim.
Counsel,
Okay.
you don't need to quote. Please proceed. We need to conclude the submissions. Thank you.
All right. So in this case, the court had held that since no claim for misrepresentation had been brought before the court, but the claim was solely on breach of contract, there could be no defense on misrepresentation, and that the parties involved should solely concentrate on the claim for breach of contract which had been raised by the claimants. Lastly, the point of duty to disclose. He reiterated the case I had mentioned earlier and stated that in that case, it was the decision of the court was upheld majorly because the parties had a fiduciary relationship. I would like to bring to notice of the court that a clear perusal of that case would indicate and would show the honorable court that the decision of the court was based on the fact that the parties had a contractual relationship, not necessarily a fiduciary relationship, but a contractual relationship. By mere presence of a contract between the claimant and the defendant, the parties had a duty to disclose their own wrongdoing by virtue of the terms of the contract binding both parties. And therefore, on those grounds, I would reiterate our submission that this court holds the claimant liable to my client, the defendant, in breach of contract, and determine this case in our favor. I rest my case.
Thank you, counsel. We will now move to the junior claimant for their rebuttal.
Much obliged, Your Honor. So I will also be replying to the rebuttal in 5 points. Number one, as mentioned by the junior defendant, the chronic diseases. That was exactly the point that the counsel was trying to make, that a chronic disease is undefined. There's no consensus at item as to what constitutes a chronic disease. The National Institute for Health puts it at 3 months or greater. The Center for Disease Control puts it at 1 year or greater. So that only sought to reiterate the point that the claimant is suffering from a chronic disease. Hence, there is no change in the condition because a chronic disease is continuous. Secondly, the exhaustion point that was mentioned by the junior defendant, and exhaustion is expected considering the grueling training that the claimant was due to undertake for the travel and training that the space flight mandated in compliance with the regulations that have been set out. Furthermore, once again, the breach is inconsequential in light of the conduct of the defendant in their subsequent gross negligence, as well as the but-for test, which is applicable in the present case. Hence, at best, the defendant is in the argument that there is a breach, at best is entitled to a set-off at most. Furthermore, the defendant quoted the contract and said all diseases must be disclosed. However, very conveniently, the defendant has left out a very important portion of the contract, all diseases that affect their ability to space travel. This is relevant in the present case as there is no consequential risk between the chronic undiagnosable headaches of the claimant and space travel itself. Furthermore, once again, the counsel would like to bring to light that the defendant themselves conceded that they had notice of the headaches through their agent, that was the sales representative, and in fact, not only had no objection, but their agent sought to encourage that what the claimant was seeking, that was a cure for their headaches, might be found on this trip to space. Lastly, the subsequent negligence in common law denies them any remedy that they can get. Furthermore, the standard of care was not taken by the defendant anyways. And lastly, the fiduciary, the case that was cited and reiterated by the defendant, it is applicable, the portion of the judgment that can be used as precedent is only for a fiduciary relationship, which does not exist in the current case. Hence, the case does not find applicability. With that, the counsel would like to wrap up his rebuttal.
Okay, thank you, both counsels. Sorry, can you guys hear me? Yeah, okay, thank you. Okay, yeah, so thank you all for your time as well. Now we will just conclude the submissions from both sides and from both counsels. It was a very good round. Really apologies for the difficulties in technical issues. and yeah, it did create a bit, bit of like discomfort, but everything was really really good, and you guys did a good job. Best of luck for the rest of the rounds, and we will just mark and score you now, and you guys can proceed to any rounds if you have for the next. I think it's 2:30. Yeah, 2:30. So thank you, thank you. Have a good day. Good luck.
Thank you so much.
Thank you.
Much.